as well?
Yeah, I'm
Just send it to the
everybody.
Yeah, thank you. I had 11:30. I don't know why. Sorry, my bad, I guess. Sorry. Thank you. Okay. Good morning. Welcome to House Human Services. This morning we are going to get the most recent information we can about S-193. I was thinking that House Judiciary would have voted out the bill this morning. I think that there's a later draft than the one that we have, which is 6.2. Is there
7.1.
7.1 now?
It's on the
Okay. It's on our page. Thank you. Thank you, Lori. And that's the most recent one, Eric, 7.1?
Exactly, yes.
Okay. Alrighty. The floor is yours, Eric. It would be helpful. We don't, there's been, well, I don't know, you have done so many different versions of this bill. I think maybe we don't need to go through, well, I don't know what to say, honestly. I'm a little befuddled about this bill, I'm just being honest with my committee members about this. Let's go and do I guess what I would call the major changes, things that really haven't changed, over the course of the different versions and that we have not provided any feedback on. We don't need to go through those. So floor is yours, Eric.
Okay, great. Eric Fitzpatrick with the Office of Legislative Counsel, here to chat with the committee about, as the chair said, the most recent version of S-193, which is draft number 7.1. I understand everyone is able to see that version on your.
Yes.
Okay, good. And I'd be happy to, as the chair suggested, to kind of focus on what the primary changes are between this draft and the previous one that this committee looked at. I think those are also related to the topics that the committee has been most interested in anyway,
Exactly.
so it kind of works well together. But I'll just note, it says more of on page 1, before even getting to that, in the legislative intent paragraph, there is on line 16. Are your versions line numbered by any chance? So if I
Yes.
say that, you
Yes,
say
they
that? Okay, great.
And even have
It
page
looks
numbers
like
now.
that.
Oh, it is? Oh,
I
great.
think it looks, just like yours. Yeah.
Oh, good. So this was a change from the House Corrections and Institutions Committee, but just to alert this committee to it as well, because I think it's an issue that's been being discussed by everybody, which is the nature and extent of the Department of Corrections' role in the operation of this facility. And so the new words on line 16 are, because the discussion previously the DOC had been limited to this security services around the outside perimeter if it's co-located on a forensic facility grounds. But through discussions, I think the committee realized that, well, many of these facilities would have an admitting area at the front where someone, and perhaps a visitor, is coming, because sometimes the visitors or other people come to these facilities for various reasons, and that it would be appropriate for DOC to be providing security there as well. And so that's why you see the new words on line 16, that DOC can provide security services at the admitting area and around the outside perimeter. So that's in a number of different places.
So I just, I realized I wasn't clear at the beginning of this meeting. For committee members, if you have an issue to flag around something that Eric is reviewing with us, please flag that. We'll come back to it unless it's an issue of making sure that you want to understand what Ledge Council is saying. And then we will have further discussion about this, because we need to know, well, now whether or not we can, they've delayed the vote on it downstairs. So I was thinking that anything we would do would have to be an amendment, but I was waiting for the bill to have substantial changes because I know the corrections and institutions changes were going to be largely in line with what our committee was thinking. So you didn't need to have two committees giving you the same information. So that was the sort of tag team that the three of us agreed to as chairs. And so, but if there are things as we go through this that are still problematic, I'll raise the ones that are for me. And please also raise the ones that are for you, because we're going to put this bill to bed, so to speak, pretty soon. Thank you. I'm sorry to interrupt, Eric.
No problem. So that brings us to the second page, which is within the not guilty by persons who have found not been competent to stand trial. And the page 2 important criteria here are what criteria goes into whether or not a person gets sent to the forensic facility at all. And this is a piece that this committee has been looking at quite a bit. And it's lines 12 to 15 of page 2. And this is the issue of when a person who would otherwise potentially be subject to Act 248, in other words, as a result of an intellectual disability is the reason that they were found not competent to stand trial. Under current law, that person would be transferred by the court to Dale custody. So the question I think that this committee and others have been grappling with is, should those folks be excluded from the forensic facility completely or partially or at all? And that's sort of what I think has been going on for the last week, if not longer, that sort of discussion. So where this proposed language lands, and which is subdivision B, as I mentioned. So these are folks who would be excluded. And you'll see the lines 12 to 14 up through the comma after the word title. That had been in here at one point, and then so that's verbatim for what was in the bill and then struck and then back in the bill. So now it's in, but there's a modifying clause that starts with the word unless. So just to think through how that works. The big picture of how it works is if the person is already in Dale custody, is an Act 248 person, in other words, it's found not competent to stand trial because of an intellectual disability, and that person's in Dale custody, then they don't go to the facility. But, and this is the unless, line 14, unless the person is detained in a correctional facility pending trial. So in other words, if the person is been, as you look at the other criteria, charged with an offense punishable by life in prison, being held without bail, pending trial, if that's the case, then the person would go to the facility. And I think the distinction there is that, I'm not a practitioner in this area, but I think everybody agrees that more often than not, someone who's charged with a life sentence, very serious offense, is going to be held without bail. Not always. There are times when it doesn't happen. They can be released. There could be bail imposed on the person. That does happen sometimes, but the most frequent result is that that person's held without bail. But if they're not, then and they're placed in Dale custody, then that person would stay in Dale custody. They would not go to the forensic facility. If they are held without bail, I think part of the rationale behind that is rather than have that person being held in a correctional facility without bail pending trial, might it actually be a better result for the person themselves as well as for public safety to have the person being treated in the forensic facility. So that's why that's at least the rationale behind the distinction.
And I appreciate this change made by judiciary. I think that this is a positive change for the people that we have been concerned about in our committee. I appreciate the committee downstairs taking into consideration that this to me sort of walks the balance between the 40 years of history that we have with Act 248 and not having had a major issue with security or reoffense or any major life sentencing impact. But as the chair of the committee shared with me, when I keep saying about, we've been 40 years without this, why do we need this? And, his comment is that, in our committee, we have to think about the future and what might happen. And what do we do if that does happen? And I think that this strikes a balance for me, that language. So those of you who have heard me complaining about this, enough, that this allows the opportunity for that person to be discharged. If they've been under Act 248, they stay under Act 248 and they go back to their community placement. The question, though, the one that you didn't bring up, Eric, because it was so many versions ago, is in the last version that our committee reviewed, 2 large B was out and now it's back in.
Right.
And can you explain a little bit about that? Because that was something, when we had our meeting last week, that I was heavily in favor of omitting that, and but now it's back in.
Right. And so the idea behind that is sort of somewhat similar to what I just said, which is that that's going to be the exception, not the rule. That's an atypical situation, because if you're in the category that's identified in line 3, you've been charged with an offense punishable by life sentence and subdivision 2. Generally, if you look at the bail statute, if you're charged with you can be held without bail if you're charged with a lifetime max offense and evidence of guilt is great. So, as I say, there are some cases where a person could be released, but in the majority of these cases, those persons are held without bail. So it's a very serious offense. But in the occasional instance where the person is released, that's what subdivision B covers. So it's the less common situation. But in that situation, they also wanted to have an ability to have the person go to the forensic facility if the person had a qualifying condition that would create a substantial risk of bodily injury. So again, it's not just anybody, but only if you met that criteria of having the qualifying condition and being, in shorthand terms, dangerous to another person. And they felt that that was a good balance between this sort of, as I say, less common situation and the 3B situation that we were just talking about, where if they were subject to an order of commitment already under Dale, in other words, that person, because that person wouldn't be being held without bail either, right? If they're already out in the community under Dale, well, they don't go to the forensic facility. But if again, atypical situation, person is released, if they're still dangerous, then it made sense for that person still to go to the.
I just wanted to bring it up because it was different in the last version that we saw.
Right.
Representative Bishop.
But if I'm understanding, they are deemed to be dangerous by the fact that they have one of these qualifying conditions.
Right, not just dangerous generally. Has to be as a result of one of the conditions. Yeah.
Okay.
Yeah, it's not great.
Yeah.
It's an area, to be honest with you, that we might propose back an amendment that takes that back out.
Right.
This, because I think if we're going to say, everybody's been saying this is punishable by life, you have, being held without bail, and then, oh yeah, but then there's this little area, so not sure exactly how I feel about that, but that's something to, yes, put a little red flag beside that. Okay, let's keep going though, Eric.
Okay, sounds good. Technical change on page 3. It does relate to, because remember, as far as the Dale population goes, there's going to be, and I think the committee did see this language, but several pages forward in the bill, there's also an opportunity for people who because what we're talking about now is whether you go to the forensic facility in the first place. If you do go, even in that situation, there's an off-ramp to be placed in Dale custody, and that's in the circumstance if the court finds that a person is not restorable to competency and not dangerous. Actually, if it's not restorable generally, the court has these options. And one option is if they're not dangerous, then they get released in the community. Another option is if they are dangerous, they stay at the forensic facility. And a third option is, well, what if it's the Intellectual Disability Act 248 population? If that's the case and not dangerous, they can be released to the same Dale Act 248 process that exists in current law. The reason I bring that up is because I'm looping back in the point that this technical change here on page 3, you're also going to see there. And that's just to clarify that how often does a person get to review those situations? Right? See lines 3 and 4, page 3.
Yes.
That was proposed by the General Counsel of Dale, which is just to be clear that it's not either or, it's both. So that you can get reviewed every 6 months. And you can also get reviewed if the medical director says, hey, wait, it looks like it's unlikely that this person's competency is going to get restored at all. So that's because you got to get a court order ultimately in all these situations, but it's the Agency of Human Services medical director who can institute the proceeding and get it going and say, or if they say, look, it looks like, hey, actually, this person has returned to competency. They can actually, they're required to let the court know about that as well. But it's not meant to be an either or situation, that if they do that, well, then the person doesn't get their 6-month review. They get their 6-month review anyway, even if that happened only 2 months ago. So just to clarify that, to make sure that it wasn't, applied incorrectly, and someone were to say, oh, no, that person doesn't get their 6-month review because the Agency of Human Services director just already instituted this proceeding 2 months ago. So that's why it says and on line 3 and then clarifies in 4 at any time upon the determination of the Human Services director. So in either of those situations, you get a review. The person gets a review. All right. So, and that is referring to the general finding about competency. The same thing occurs on page 5. That's lines 18 through 20 or so. In version 7.1, you'll see and that's the case. That's a situation where the court has found that the person is dangerous and stays there. And if that's the case, they still get reviewed, but it's every 12 months instead of every 6 months. And that's just clarifying language to also provide that, hey, they get that review every year. And if the medical director anytime sooner says, hey, I don't think they're dangerous anymore. So that's that process. But again, as I mentioned, and this is this is a change to the Dale piece, which starts on page 7, line 18.
So I'm sorry, just before you move there.
Yeah.
Hate to do this, but I'm back on page 4.
Right.
And we're talking about the risk assessment.
Yep.
So one of the things that I think is important is to recognize the differences in risk assessments for people of different populations. And so I think, I guess I'm going to want to work with you on some language that identifies that the risk assessment is appropriate to the disabilities of the individual or the diagnosis, or I don't know exactly how to say it, but there are evidence-based risk assessments for people with developmental and intellectual disabilities that are different than other evidence-based risk assessments for either people in the general population or people with mental health diagnoses.
Mhm.
So I don't have a level of comfort in just saying risk assessment, that appropriate risk assessments would be used, or maybe we should say clinically appropriate risk assessments or something to that nature that indicates that they would be, they're different for different populations. So I'm just flagging that for people. I think we will suggest language around.
Sure. And just when you do that sort of thing, I just suggest let's make sure and loop Katie in. She tends to know more about that particular.
Yes, I'm always making sure to CC you and Katie.
Great, thank you. And I don't know that this necessarily resolves your concern about what you want to see addressed, but that was, I think, at least in part, the reason for the addition of top of page 5, lines 1 and 2, that was added, that the opinion has to include whether the person is in need of custody care and ability.
Yes.
So that's at least part of that, the intellectual disability part, but I don't think it necessarily covers all of what you're thinking.
Yeah.
Similar idea maybe for other folks you're thinking.
Right. And that language is right out of Act 248.
Yes, exactly.
Yeah. Okay, thank you.
Yeah,
Sorry.
you bet. So that brings us to, speaking of Act 248, over on page 7, line 18. So this, as I mentioned, this is when someone is found non-restorable. So there's a person that can't be restored. Court has a couple of other options other than this one, but this is the option where if that person's competency can't be restored, and you see line 19, this is what you just said, right, from Act 248. If by clear and convincing evidence, the person is the person in need of custody, care, and rehabilitation, that's the intellectual disability that's caused the lack of competency, then the court shall issue an order for up to 1 year, this jumps over to page 8, to Dale for placement in designated program, least restrictive environment, et cetera. That language is all verbatim, just cut right out of Act 248. So that's the off ramp that we were talking about. Once a person is determined to be not restorable, court has the option, if they qualify for Act 248, to place the person with Dale as opposed to remaining at the forensic facility or being released into the community. Now, if that happens, this is a change here to look at that this committee I don't think has seen yet, is that because you think about time limits here, and that's something that the Dale commissioner was speaking about quite a bit in the Judiciary Committee, how this was going to work in order to find the designated program for the person. So the place where the Judiciary Committee had it initially landed was, you see lines 13 to 15, page 8, that the placement at the, sorry, so if the, what
Line
the
16 and 17.
yes, well, yeah, and even that, before, just sort of think about where that's coming from, is that the commissioner is supposed to provide, lines 10 and 12, commissioner has to provide appropriate care, custody, care, and rehabilitation at a designated program if the person comes in through this route. However, then you go on to Roman 2, line 13, if the commissioner doesn't have a designated program yet, then the court, he sets line 13, may order continued treatment at the forensic facility, but says for a period not to exceed 1 year. So kind of the way it had been written was, if you don't have a program yet, we'll give you 1 more year to find one. Based on testimony from the commissioner and the general counsel downstairs, they said, well, what if, 1 year, what can we do if it's not, we haven't found a place yet? So that's why that new sentence is in line 16, 17. For good cause shown, the court may extend the 1 year period by an additional period not to exceed 6 months. So it's only 6 months more, and it's only if the court finds that there's good cause. If that's the case, then there might be an additional period granted for the commissioner to find a appropriate designated program for the person. But it can't go longer than 18 months. That's the max.
And it was important that there be a time limit. And I think actually way back when there wasn't a time limit set. And then we got to 1 year, and then the commissioner testified that most cases they can do that within 1 year, but they have had on occasion a need to extend that beyond. So, but the part that I think makes this palatable is that they have to go to the court and they have to make the case to the court. They don't just get that automatically.
Yeah.
So presumably they'd have to present information about their efforts to create or obtain a placement for the individual in order to prove to the court that they've made those efforts.
Yes, definitely. The courts are familiar with the for good cause shown standard, and it requires some affirmative showing. So it wouldn't just be granted as a matter of course. So in any event, these orders for continued treatment get reviewed every 90 days. Again, and the commissioner can at any time, that's over on page 9, line 8. If at any time the commissioner finds it looks like there is a designated program available, then they can come to the court and say, we've got a program, court vacates the order for continued treatment and sends the person to the program. So that's the idea. Otherwise, and as you see in subsection D, other than that, the court stays at the person stays at the forensic facility, but this is that off ramp for the Act 248 population. The person gets competency restoration provision all the time that they're there. I think this, because there haven't been any changes to the involuntary medication piece, which starts on page 11. There have been some changes to the rights of victims, some clarification on their ability to be heard at these proceedings. That's really it for any substantive changes to that section. And then the next section, which starts on page 13, having to deal with NGRI population, not guilty by reason of insanity, has a similar change that we just talked about, that the at any time language to make sure that the person can have their commitment reviewed on this periodic time schedule, or at any time that the medical director certifies to the court that it looks like the person is no longer dangerous. That's on page 16.
So I'm gonna, I think Eric, because that's not our area of
Right.
jurisdiction.
Yeah.
I think that we can forego that.
Okay.
So,
You wanted to talk a little bit about DOC's involvement, some of the changes that House Corrections made
Yeah.
there?
yeah,
Okay, so that starts on page 19, section 5. This is the definitions section, but as well, the section that specifically lays out what the roles are of the various departments within the Agency of Human Services and the Department of Corrections. So you see it's sort of, and this is some clarifying language from HCI on page 19, line 14, clarifying that Agency of Human Services provides for secure competency restoration, evaluation, stabilization, treatment, and care of folks who are there at the facility, who have been involved in the legal system. Then, if you look over on page 20, subsection B starts on line 10.
before you move there,
Yeah.
I just, because there's been some discussion in committee about what does qualifying condition mean?
Mhm.
So I just want folks to really, ask if you have any questions about what that means on lines 19 through 21. I just am wanting to highlight that for people. If you have any questions, now's the time to bring them up with Eric. Okay, all right, thank you.
Yeah, sure. On that same page, though, the next page, or depending on your version, on page 20, subsection B, this is a subsection that really delineates the respective responsibilities of the Agency of Human Services Medical Director and DOC. So that's good language to look at carefully. So generally speaking, Secretary, it's Human Services that establishes and operates, that's line 10, shall establish and operate the locked, secure forensic facility for competency restoration, evaluation, stabilization, treatment, and care, that same phrase we just looked at. Of persons who've been transferred pursuant to, and those two sections are the two sections that we just talked about. Competence, been found incompetent to stand trial or not guilty by reason of insanity. So this facility is only for folks who have come through the criminal justice system through one of those two avenues. That's it. And it's not anybody who's been in the criminal justice system. They have to have been charged with a lifetime offense, which is only about a dozen offenses. And at least from the competency perspective, they as well, or they're either being held without bail or possibly in the community and having been found dangerous. But most likely, they're going to be held without bail when you're charged with a lifetime of an offense with a lifetime max. So that's who that's for. Then next sentence, line 13, forensic facilities, clinical, forensic, and competency restoration services shall be overseen by the Agency of Human Services Medical Director. So you see, so they're the one who covers clinical, forensic, competency restoration. Then it goes on to say, the next sentence, and this is what came out of House Corrections and Institutions Committee, Department of Corrections shall not play a role in the forensic facility's operation, provision of services, or internal security, except to provide security services for the facility at the admitting area, that's out front, and around the outside perimeter of the facility, if it's co-located on the grounds of a correctional facility. So that is an attempt to delineate the respective responsibilities of the different departments. Then it sort of itemizes what the various duties are of the forensic facility over the next couple of pages about therapeutic recovery-oriented care, et cetera, how they can't refuse people that are admitted. Again, subdivision 3, line 21, outlines that it's competency restoration, evaluation, treatment, stabilization, and care, including the ability to separate population by sex or gender. That's all, and the operation of multiple facilities also. And this is, as I say, a pretty long list, but subdivision 4.2 clarifies that it's the direction of the medical director who oversees forensic clinical competency restoration services, and they provide that instruction to the facility generally. I don't know if it came from this committee, but and it was Katie who talked about this. I didn't, but I know that it's new between this draft and the last one you looked at, which is page 22, line 16 to 18. That part of what is going to be the duties of the facility includes to implement a process for reporting instances of death or serious bodily injury to residents of the facility to the medical director. So there's this information loop going on if something happens there.
It previously said to the Department of Mental Health, and we said, and it was only about people with mental health issues. And so we said yesterday, I think when Katie was here, was yesterday, that should be for anybody at the facility if there is a bodily injury issue.
Right.
Serious. It should be for anybody, not just people with mental health challenges. So, yeah, that did come from us.
That's what I thought. The feasibility plan, I don't see any other changes there that, but I can pause in case there's other things you want to ask about.
We've had a pretty thorough review of the feasibility plan. Does anybody have any questions about that? I don't think that's changed any since the last time we saw it yesterday. Okay.
One thing, are we talking about feasibility plan?
I just was checking to see if anybody had any questions on it. It doesn't appear that they do, but
Okay.
if you have something you want to highlight, go ahead.
Well, just there was one new piece, and that's that you may recall that the feasibility plan also has to include an option for people to get competency restoration treatment before this forensic facility, because remember, this is 2 years out before it becomes effective and operational. That's the theory. So the idea was, well, what about in the meantime? So that's subdivision 12 over page 26 to 27, that the feasibility plan also has to include opportunities and cost estimates for a person to receive a competency restoration services. Let's crank over to page 27. Before I missed it. Where was it? Oh, yeah, sorry,
Well,
page 26, while the development is pending.
Pending,
So it's
yeah.
before the facility is in effect, while it is pending, they could still get these services is the idea. But there's a sunset. So if you look at page 28, lines 9 to 11, that subdivision that we're just looking at only goes until the same time that the forensic facility itself becomes operational in 2028. So that's a temporary language to provide for possible competency restoration services before the facility itself becomes operational.
And it seems like just before that on subparagraph 11,
Yep.
that developed in consultation with the Department of Corrections. So in terms of the community monitoring plan. So, and this is, so this version reflects the vote out of committee out of corrections and institutions, correct?
Yes.
Okay, so they're okay with that.
Yep. That was language drafted at their direction.
Go ahead, Reverend Meyer.
So, I'm sorry, could we ask which line, where are we looking, which page and line are we just?
That was page 26, sort of lines 13 to 20-ish, but in particular, line 13 and 14, I think the chair was just referring.
Thank you. Sorry.
Oh, no. So, I'm going back to something I asked yesterday. From what I'm hearing, it sounds like there's been language placed in there that's providing and contemplating temporary placement within a DOC facility, yet not DOC providers. And that placement is temporary and available and sunsets once the feasibility study is been completed and the originally as outlined is comes online.
Yeah, I think that's right. Yep.
Fair. All right.
Or out of state.
Or out of state.
Yeah.
I guess the point I'm getting at from yesterday, it was like, okay, well, you have this feasibility study, but we still have the same status quo in place where we have no placement, whereas now there is language in there that we can temporarily place them in there, begin a restorative competency restoration program. That again, competency restoration pertains to whether or not they are able to be found competent to stand trial or not competent to stand trial, correct?
Exactly.
All right.
Yep.
I think it's important just to be clear on that because I'm hearing a lot of like unclarity that all around, like
Right.
we are looking to restore everybody's intellectual disabilities. That's not the case. Restoration is strictly pertains to whether or not the individual is able to now go and stand trial or not.
Right. That's what the compensator, I think even that there's a definition of that was, I can't remember if it was in the.
Yeah, I did see it.
But yeah, so it's related
That's
to
it.
ability to stand trial.
Thank you, Laura.
Yep.
And we didn't go over this section, but I'm presuming the issue that I asked about when I was interloping on corrections and institutions the other day about supervision versus custody. The
Right.
custody is still only people with intellectual and developmental disabilities, and supervision for everybody else
At the moment.
at
Yep.
the moment.
Exactly. I think that's one of the things that
I mean, I think
even in
that's-
the interim, they have to look to study that, but as currently drafted, yes. that's-
Yes, okay.
Yeah.
So, committee members, I think that, what this is sort of winding up with, the one thing that I would like us to, and I'm gonna ask for some language development so that you can see it on paper, but just so you know what I'm going to do. I'm going to ask, right now, there isn't anything that says when the court is looking to potentially discharge somebody, it doesn't reflect that, what would be the person's stance if services were provided in the community as a part of why they would be discharged or why they could be discharged. So what I'm not saying very clearly, and which I need help with wording about, is so that absent these services, the person would still be dangerous. But with these services in the community, they could be discharged without being dangerous. So lots of times if you're just discharged and this is the part of the problem, you're out there and you've just been discharged and you don't have any follow-up services and you're still dangerous, then that's not okay. But if you have services and they're in place, then that should be part of what the court considers when they're deciding whether or not you can be discharged. That's not, that it doesn't read that way right now. And then the other thing is about the risk assessment by appropriate clinical risk assessments that are appropriate to the clinical needs of the individual. And then page 2, lines 6 through 8, still
Yeah.
for me.
Can I look back to that for a moment?
Yeah.
I guess, and maybe it's just an addition of a word or two, but if we look at line 6 through 8 on page 2, persons held is not held without bail, has a qualifying condition that upon the person's release would create a substantial risk of bodily harm. So it seems like the qualifying condition, the very fact that you have a mental, congenital, or traumatic or other condition is what causes you to be a substantial risk of bodily harm or injury to other persons. Should it read, has a qualifying condition that upon the person's release, and that upon the person's release, it has been determined that there'll be a substantial risk of harm, then they could be held in the forensic facility. But there seems to be a conflation of things.
Exactly. You said it better than I have been trying to say it. it's, and Eric and I have debated this one going back and forth. They're talking about it being the qualifying condition that causes them to be dangerous, and that's not the
Yeah, so
point.
I'm not stating an outright objection to lines 6 through 8. I just don't think it conveys what I believe we're trying to convey, is that someone may have a qualifying condition and has been deemed to be the risk and is not being held without bail, that they could qualify to be in the forensic facility. So there's just, it's a language issue. I don't think it's an intent issue unless I'm misreading it, but
So I'm gonna ask for some language change on this one, so maybe we can compare notes. Yeah.
Just gonna go, chances are I will not support any level of that type of language because there is a distinction between some criminogenic elements and mental health. And when you're leaning more towards, we're assuming with that type of language that all competency or inabilities to be incompetent to stand trial is strictly mental health. There are times when it's criminogenic, which is a completely separate, those are not diagnosis and things.
I agree.
Again, we're going off of circumstances, not diagnosis. So I just wanted to make you aware that I will have a difficult time supporting any type of amended language associated to some of the suggestions.
Yeah.
But I respect them and I appreciate it. Thank you.
Thank you.
maybe outside of this, you can help me better understand criminogenic. I'm not familiar with that.
Criminological.
Yeah, I'm just not sure what we're talking about.
Okay, I want people to have a chance to have time for lunch. Thank you very much, Eric.
Yeah, absolutely.
Appreciate it. And
Yeah.
as we said to Katie yesterday, appreciate all the work that you've done on this. I know it has been such a slog with so many committees looking at it at the same time.
So it's one of those areas where it really does cross the jurisdiction of a lot of different committees.
Yeah.
So some of those are more complicated to staff and handle, but sometimes that's just the way it is. And this happens to be one of those bills. So got me in here sometimes, which I'm not always in here. So that part.
I know, we like seeing you, so thank you.
Thanks. In here.
Alrighty, thanks very much.
You bet. Let us know if you have any questions.
Alrighty. Okay, folks, so Lori, this will be it for today because the rest of the time will be spent on the floor. So have fun.